Welcome to the Bill of Rights and Other Amendments class by the Grumpy Old Vet. This is Lesson 22 in this series. This lesson will cover the Bill of Rights and the 10 articles that were part of that one document, even though they are referred to as the first 10 amendments, and the subsequent additional 17 amendments added up to date. With that, let's move out. Welcome to the class, Bill of Rights and Other Amendments, brought to you by the Hillsdale Justice Project at Liberty Hall. Narrated by John Rutan. Article 1. Freedoms, Petitions, Assembly. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Ratified on December 15, 1791. Congress cannot create laws that establish a religion, interfere with religious practices, limit free speech or the press, or prevent peaceful assembly and petitioning the government for complaints. Article 2. Right to bear arms. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. Ratified on December 15, 1791. The people have the right to own and carry weapons to ensure the security of a free state. Article 3. Quartering of soldiers. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Ratified on December 15, 1791. Soldiers cannot be housed in private homes without the owner's consent, except as law allows during wartime. Article 4. Search and arrest. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. Ratified on December 15, 1791. People have the right to be free from unreasonable searches and seizures. Warrants can only be issued with probable cause and specific details. Article 5. Rights in criminal cases. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. Ratified on December 15, 1791. No one can be tried for serious crimes without a grand jury indictment, except in military cases. You can't be tried twice for the same crime, forced to testify against yourself, or lose life, liberty, or property without due process. Private property can't be taken for public use without fair compensation. Article 7. Right to a fair trial. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Ratified on December 15, 1791. The accused has the right to a fast public trial by an unbiased jury in the district where the crime occurred, to know the charges, confront witnesses, gather evidence, and have a lawyer for defense. Article 7. Rights in civil cases. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Ratified on December 15, 1791. In civil cases over $20, the right to a jury trial is guaranteed, and facts decided by the jury can't be re-examined by another court, except as allowed by common law. Article 8. Bail, fines, punishment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Ratified on December 15, 1791. No excessive bail, fines, or cruel and unusual punishments. Article 9. Rights retained by the people. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Ratified on December 15, 1791. Listing some rights doesn't deny others the people have. Article 10. States' rights. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Ratified on December 15, 1791. Powers not given to the U.S. or denied for states belong to the states or people. Amendment 11. Lawsuits against states. The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. Ratified on February 7, 1795. U.S. courts can't hear cases where a state is sued by citizens of another state or foreign country. Amendment 12. Presidential elections. The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom at least shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president, and they shall make distinct lists of all persons voted for as president, and of all persons voted for as vice president, and of the number of votes for each, which lists they shall sign and certify, and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be the president, if such number be a majority of the whole number of electors appointed, and if no person have such majority, then from the persons having the highest numbers, not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately, by ballot, the president. But in choosing the president, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president, whenever the right of choice shall devolve upon them, before the 4th day of March next following, then the vice president shall act as president, as in the case of the death or other constitutional disability of the president. The person having the greatest number of votes as vice president shall be the vice president, if such number be a majority of the whole number of electors appointed, and if no person have a majority, then from the 2 highest numbers on the list, the Senate shall choose the vice president. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of president shall be eligible to that of vice president of the United States. Ratified on June 15, 1804, the section in yellow, superseded by Section 3 of the 20th Amendment. Electors vote separately for president and vice president. If no president gets a majority, the House of Representatives picks the president by state votes. If no vice president gets a majority, the Senate picks the vice president. If the House can't choose a president by March 4th, the vice president acts as president. Amendment 13. Abolition of slavery. Section 1. Neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. Section 2. Congress shall have power to enforce these articles by appropriate legislation. Ratified on December 6, 1865. Slavery and forced labor are banned, except as punishment for a crime. Congress can pass laws to enforce this. Amendment 14, Civil Rights. Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Anyone born or naturalized in the U.S. and under its jurisdiction is a citizen. States cannot deny citizens' rights, take away life, liberty, or property without due process, or deny equal protection under the law. Amendment 14. Civil Rights. Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age, and citizens of the United States, or in any way abridged, except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. Representatives are apportioned based on the total population, excluding untaxed Indians. If voting rights are denied to eligible male citizens, representation is reduced in proportion to the number of disenfranchised men. Amendment 14. Civil Rights. Section 3. No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. Anyone who has taken an oath to support the Constitution and later engages in rebellion or aids enemies cannot hold public office, but Congress can remove this restriction with a 2/3 vote in each house. Amendment 14. Civil Rights. Section 4. The validity of the public debt of the United States, authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave. But all such debts, obligations, and claims shall be held illegal and void. Section 5. The Congress shall have power to enforce, by appropriate legislation, the provisions of this article, ratified on July 9, 1868. The U.S. public debt, including pensions for those who helped suppress rebellion, is valid and cannot be questioned. However, debts related to aiding rebellion or claims for the loss of slaves are illegal. Congress can enforce these rules through legislation. Amendment 15. Black Suffrage. Section 1. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Section 2. The Congress shall have power to enforce this article by appropriate legislation, ratified on February 3, 1870. Citizens' right to vote cannot be denied based on race, color, or past slavery. Congress can enforce this through legislation. Amendment 16. Income taxes. The Congress shall have power to lay and collect taxes on incomes, from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration. Ratified on February 3, 1913. Congress can tax incomes without dividing it among states or using a census. Amendment 17. Senatorial elections. The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election as the legislature may direct. Amendment 17, Senatorial Elections. This amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution, ratified on April 8, 1913. The Senate consists of 2 senators per state, elected by the people for 6 years. If a vacancy occurs, the state's governor can temporarily appoint someone until a special election is held. This amendment doesn't affect senators already elected before it was enacted. Amendment 18, Prohibition of Liquor. Section 1. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within, the importation thereof into, or the exportation thereof from the United States, and all territories subject to the jurisdiction thereof for beverage purposes, is hereby prohibited. Section 2. The Congress and the several states shall have concurrent power to enforce this article by appropriate legislation. After 1 year, the manufacture, sale, or transportation of alcohol is banned in the U.S. Congress, and states can enforce this law. Amendment 18, Prohibition of Liquor, Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states, as provided in the Constitution, within 7 years from the date of the submission hereof to the states by the Congress. Ratified on January 16, 1919. Repealed by the 21st Amendment on December 5, 1933. This article will only take effect if ratified by state legislatures within 7 years. Amendment 19, Women's Suffrage. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any states on account of sex. Congress shall have power to enforce this article by appropriate legislation, ratified on August 18, 1920. Citizens cannot be denied the right to vote based on sex. Congress can enforce this. Amendment 20, Terms of Office. Section 1. The terms of the President and Vice President shall end at noon the 20th day of January, and the terms of senators and representatives at noon on the 30th day of January, of the years in which such terms would have ended if this article had not been ratified, and the terms of their successors shall then begin. Section 2. The Congress shall assemble at least once in every year, and such meeting shall begin at noon on the 3rd day of January, unless they shall by law appoint a different day. Presidential and congressional terms end on specific January dates, and their successors' terms begin then. Congress must meet at least once a year, starting on January 3rd, unless another date is chosen. Amendment 20, Terms of Office, Section 3. If at the time fixed for the beginning of the term of the President-elect shall have died, the Vice President-elect shall become President. If a President shall not have been chosen before the time fixed for the beginning of his term, or if the President-elect shall have failed to qualify, then the Vice President-elect shall act as President until a President shall have qualified. And the Congress may by law provide for the case wherein neither a President-elect nor a Vice President-elect shall have qualified, declaring who shall then act as President, or the manner in which one who is to act shall be selected, and such person shall act accordingly until a President or Vice President shall have qualified. If the President-elect dies or doesn't qualify, the Vice President-elect becomes President. If neither President nor Vice President-elect qualifies, Congress will decide who will act as President until one qualifies. Amendment 20, Terms of Office. Section 4. The Congress may by law provide for the case of the death of any of the persons from whom the House of Representatives may choose a president, whenever the right of choice shall have devolved upon them, and for the case of the death of any of the persons from whom the Senate may choose a vice president, whenever the right of choice shall have devolved upon them. Congress can make laws for situations where a candidate dies during the process of selecting a president or vice president by the House or Senate. Amendment 20, Terms of Office. Section 5. Sections 1 and 2 shall take effect on the 15th day of October, following the ratification of this article. Section 6. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission. Ratified on January 23, 1933. Sections 1 and 2 start on October 15th after ratification. The article won't take effect unless 3/4 of states ratify it within 7 years. Amendment 21, Repeal of Prohibition. Section 1. The 18th article of amendment to the Constitution of the United States is hereby repealed. Section 2. The transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors, in violation of the laws thereof, is hereby prohibited. The 18th Amendment, prohibition, is repealed, but transporting or importing alcohol against state laws remains illegal. Amendment 21, Repeal of Prohibition. Section 3. The article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states, as provided in the Constitution, within 7 years from the date of the submission hereof to the states by the Congress. Ratified on December 5, 1933. This amendment takes effect only if ratified by state conventions within 7 years. Amendment 22. Term limits for the presidency. Section 1. No person shall be elected to the office of the president more than twice, and no person who has held the office of president, or acted as president, for more than 2 years of a term to which some other person was elected president shall be elected to the office of the president more than once. But this article shall not apply to any person holding the office of president when this article was proposed by the Congress, and shall not prevent any person who may be holding the office of president, or acting as president, during the term within which this article becomes operative from holding the office of president, or acting as president during the remainder of such term. No person can be elected president more than twice, or serve more than 2 years of another president's term, except for the current president at the time of this amendment. Amendment 22, Term limits for the presidency. Section 2. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission to the states by the Congress. Ratified on February 27, 1951. This amendment won't take effect unless 3/4 of the states ratify it within 7 years. Amendment 23, Washington, D.C., Suffrage. Section 1. The district constituting the seat of government of the United States shall appoint in such manner as the Congress may direct a number of electors of president and vice president equal to the whole number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered for the purposes of the election of president and vice president to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th article of amendment. The District of Columbia can appoint electors for president and vice president equal to the number of senators and representatives it would have if it were a state, but no more than the least populous state. These electors will act like electors from a state in the election process. Amendment 23, Washington, D.C., Suffrage. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Ratified on March 29, 1961. Congress can create laws to enforce this article. Amendment 24. Abolition of poll taxes. Section 1. The right of citizens of the United States to vote in any primary or other election for president or vice president, for electors for president or vice president, or for senator or representative in Congress, shall not be denied or abridged by the United States or any state by reason of failure to pay any poll tax or other tax. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Ratified January 23, 1964. Citizens can't be denied the right to vote in elections due to unpaid taxes. Congress can pass laws to enforce this. Amendment 25. Presidential succession. Section 1. In case of the removal of the President from office, or of his death or resignation, the Vice President shall become President. Section 2. Whenever there is a vacancy in the office of the Vice President, the President shall nominate a Vice President who shall take office upon confirmation by a majority vote of both houses of Congress. If the President is removed, dies, or resigns, the Vice President becomes President. If the Vice President's office is vacant, the President nominates a new one, confirmed by Congress. Amendment 25. Presidential succession. Section 3. Whenever the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. If the President declares in writing that they can't perform their duties, the Vice President acts as President until the President declares they can resume their duties. Amendment 25. Presidential succession. Section 4. Whenever the Vice President and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide, transmit to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Amendment 25. Presidential succession. Thereafter, when the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that no inability exists, he shall resume the powers and duties of his office, unless the Vice President and a majority of either the principal officers of the executive department or of such other body as Congress may by law provide, transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office. Amendment 25. Presidential succession. Thereupon Congress shall decide the issue, assembling within 48 hours for that purpose, if not in session. If the Congress, within 21 days after receipt of the latter written declaration, or if Congress is not in session, within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the President is unable to discharge the powers and duties of his office, the Vice President shall continue to discharge the same as acting President. Otherwise, the President shall resume the powers and duties of his office. Ratified on February 10, 1967. If the Vice President and majority of officials declare the President unable to perform duties, the Vice President becomes acting President. If the President disagrees, they can resume duties unless Congress, with a 2/3 vote, determines the President is still unable. Amendment 26. 18-year-old suffrage. Section 1. The right of citizens of the United States, who are 18 years of age or older, to vote shall not be denied or abridged by the United States or by any state on account of age. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Ratified on June 30, 1971. Citizens 18 and older can't be denied the right to vote due to age. Congress can enforce this with laws. Amendment 27. Congressional pay raises. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. Ratified on May 7, 1992. Note: Congress submitted the text of this amendment as part of the proposed Bill of Rights on September 27, 1789. The amendment was not ratified together with the first 10 amendments. Senators and representatives' pay changes can't take effect until after a new election. This concludes the 22nd class in the series on the Bill of Rights and other amendments. I hope you found the information helpful and entertaining. I will see you in Class 23, which will be the film The Dangers of Democracy, in the series The Constitution is the Solution by the John Birch Society with Dr. Robert Brown. Fall out.